Garden State TLE. 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 Garden State TLE.
Your name is Matthew Rogalski.
This is true.
Assistant prosecutor?
True.
Lifelong professional prosecutor?
Mostly true, yes. I had a prior career for a very short time, but I'm largely a lifetime prosecutor.
And having spent many, many years with the Mercer County Prosecutor's Office.
Correct.
And there's very few jobs, including sweeping up, that you haven't done over there over the decades. Correct?
That's true. I've been in grand jury, juvenile, forfeiture, arson, trial team.
Don't forget expungements.
Expungements, prosecuted several homicides. Yeah, just about every. I've had my thumb in every pie.
All right. Well, we're going to take advantage of your expertise today and talk about something that very few people know about, and everybody should know about, which is grand jury. Okay. And I really want to kind of take the grand tour of the grand jury, so to speak, today. Okay. And I'm going to kind of pose some questions for you. We start off with the proposition, which a lot of people in New Jersey don't realize, about the constitutional component of the grand jury. This is something that is not incumbent upon the states. In other words, the Supreme Court of the United States has never made a presentation to a grand jury on a state level required. So it's really a question of state law, and different states have adopted different techniques to make sure there's some screening mechanism of allegations of criminal conduct before they get to the trial stage. We, in New Jersey in 1947, selected the grand jury procedure. And I just want you to talk for a couple seconds about the distinction between an indictment, presentment, and an accusation. Can you talk about that?
I can. As you pointed out, several states, in fact, haven't adopted grand jury. Pennsylvania is one of them. Mm-hmm. They have probable cause hearing. In New Jersey, we have the possibility, or the procedure rather, of indictment, which is usually when a local authority, such as a township or some subdivision of the township, brings a formal charge against an individual. If it's of sufficient severity, it winds up going before the grand jury. It gets presented not usually directly to the grand jury. In a sense, it gets washed through the prosecution process. So we are able to eliminate and identify certain charges as good, bad, or irrelevant for a presentation to a grand jury. A presentment has to do with a grand jury deciding that they want to investigate a given issue within the statutory powers that are given them. So it doesn't even necessarily have to generate from us. They can become aware of a public policy or a public issue and go forward from there. And I'm sorry, the last
accusation.
Oh, accusation is a way to bypass the entirety of grand jury, because you have a right to have indictable charges brought before a grand jury. When you waive that, you can generally agree to plead to an accusation, which is a formalization of a charge that comes from below, but not necessarily. It can come horizontally from the prosecution itself and directly from us.
All right, let me kind of go back step by step, and I'm going to make some statements. Tell me whether I'm right or wrong. All right. First of all, we can both agree that the requirement for grand jury intervention is embedded in our state constitution as part of the 1947 Constitution. So this is not something that's, it's not a choice. This is the way things have to go in New Jersey.
Absolutely, yes.
Okay. Now, as a prosecutor, you have to be cognizant that you have limited resources to do your job, and the amount of resources you have available to you are a function of politics and how much the county freeholders is willing to provide to your office. Agree?
I agree. It's also based on the tax base, the other types of investments the county wants to make in the county itself outside the criminal justice system. But there's a number of...
The point I'm trying to make, there's a finite amount of resources available for crime fighting, so to speak, at the prosecutor office level.
Sure.
So it means that you're going to have to exercise a certain level of discretion in terms of how you're going to handle all these cases coming in. Okay? Now, what are the possibilities? You have a bunch of cases been plopped on your desk. You're going to review them.
Mm-hmm.
Some of them don't merit anything and should be dismissed outright because there's just nothing there that's significant enough to prosecute. Some should be sent to the municipal court for prosecution because the conduct either meets the criteria for a lower type charge, a disorderly person offense, or a petty disorderly person offense, or the defendant will get quicker justice and probably more punishment in municipal court than he will in superior court. So you would divert those cases back to municipal court.
Yeah, it's called a downgrade.
Okay, downgrade them. And then certain cases they're of serious enough stature that they should be considered on a track that could ultimately wind up before the grand jury.
Absolutely, yes.
Okay.
We call it screening.
Okay, and that's the point. The screening mechanism is really a function of the amount of resources you want to address, but there's also this concept of jury appeal. And I really want you to talk for a few seconds about what it is about a case that gives it sufficient jury appeal that you want to send it on its way to the grand jury as opposed to sending it to municipal court or diverting it in some other way.
I got to tell you, you want honest answers?
No, lie to us. Make up fairy tales.
I got to address that. The words jury appeal really is, from my personal standpoint, I wouldn't be concerned about that until I was reviewing attorney for purposes of trial, because that's when I would be setting plea agreements. That's when I would be evaluating, for lack of a better phrase, the value of a case, whether it had jury appeal. And by jury appeal, I don't want people to misunderstand and think, oh, it's sexy, it's interesting, blah, blah, blah. Victims are victims. Sure. Whether their cases are provable or not provable vis-a-vis the money we can throw at it to do massive investigations versus smaller investigations, the amount of personnel we have to knock on doors to increase the level of investigation, all those things are important. But I don't think the phrase jury appeal, I'm not comfortable with that particular
Can I challenge you on it? On this? Let me just give you a fact pattern. An individual, Mary X, is apprehended by store security in a mall, and she is shoplifting stuff. They detain her for the police, come, and the people sign a complaint against her, charged with shoplifting. The value of the shoplifting materials is $201. Now, that constitutes a crime of the fourth degree under New Jersey law, okay? If that case comes to you, is that something you want to take to the grand jury and try in front of a jury?
No, but I don't think that would be a matter of whether it's got jury appeal or not. That would be, I think, a consideration of using our resources where they're best spent on more serious crimes, sexual assaults, physical assaults, robberies, things like that. It doesn't make sense for us to chase after shoplifters at $201. Right. I have had cases where, believe it or not, I was literally the first prosecutor who inherited a woman who had 45 shoplifting arrests. And you can imagine, she's either the worst shoplifter in the world or she's been doing it professionally for years and got caught 45 times. And it's funny because the number you're mentioning, of course, is the difference between a DP and a crime. Right. She had negotiated 45 times to go below $200.
I think I had her on number 37.
You may have. I think most every attorney probably did. I was the first guy ever to tell her attorney, no, I'm not going below it. She's a pro. I'm not going to reward her for her intelligence by not stealing too much. Well, so she wound up going to prison.
Well, let's look at it this way. I mean, you have a certain series of crimes that are going to go to the grand jury all the time. So yes. Let's say it's a crime of the first degree, it's going to go. For the most part, crimes of the second degree, they're going to go too. For the most part, all right? And then you'll have the more nebulous types of things, which are crimes of the third and fourth degree, where you have people, it's either subject to be downgraded or the people are their first offenders. You know, they may be subject to diversion from the criminal justice system completely through the pretrial intervention program, something of that nature. That's not to say that they couldn't go to the grand jury, but they may not. But, I mean, is there any set of criteria that people could just generally look at and say, look, this case is going to grand jury, forget about it, you know? pretty much every time.
Sure. You know what? While you were just mentioning that, the phrase jury appeal, I think is probably better understood in the context of what is important to the community right now.
Right.
For instance, there's debates nationwide. Should we legalize marijuana? Marijuana, at one time in New York State, as you know, carried with it horrific sentences. People had to be released from jail in the early 70s because they had gotten, I believe, life sentences for relatively small amounts of marijuana relative to big-time drug dealers. And nationwide, there were releases from prison because people realized marijuana is not this issue, not a life sentence issue. And certain crimes today are recognized by society as being more serious or less serious, depending on how society views them.
It's part of societal evolution, basically.
Oh, absolutely. Child pornography is a relatively new phenomenon, at least in the popular culture and their awareness of it. So it's been taken very seriously. It's existed for a long time, but now it's one of those things that just is not forgiven anymore.
Interestingly, and viewed much more seriously by the federal government than the state of New Jersey at this point, although I think the legislature will catch up to the federal government.
That and the feds have incredible resources for tracking this information down and being able to do widespread investigations with virtually unending pocketbooks.
All right. Well, we really have kind of touched upon initially the two main functions of the historic functions of the grand jury. You have an accusatory function and an investigatory function, all right? And I want to talk about the accusatory function for a couple seconds, since that's really kind of the topic we're on. Let's say there's a particular case that it shouldn't be screened out. This case is just going to the grand jury, all right? And the likelihood is going to be a pretty serious case, or somebody who just needs to be prosecuted aggressively because of prior criminal history or the facts and circumstances surrounding the case. There's something aggravating about the case that it really needs to be taken seriously. Okay? Are you a believer that these cases should be presented to the grand jury by the attorneys who are going to ultimately try them before the petit jury, or do you believe in the idea that there's just a kind of a team process that each section is going to hand off? In other words, one person will prep it, another person will present it to the grand jury, then a third person will try the case. What do you think?
I think in
the horizontal vertical prosecution.
The vertical prosecution model is wonderful if you have about 5 times the staff that we do. I don't think they do it in New York. I'm not aware of.
Can you explain to our viewers what vertical prosecution means?
A police complaint would come in alleging an armed robbery. That would come past my desk for first screening. I would screen it as a real case or one that can actually be prosecuted and should go to trial. I would then formulate the appropriate additional charges, if any, that would go with a simple robbery allegation.
So there may be
bring it to grand jury.
A weapon, unlawful possession of weapon,
burglary, trespassing, threats, aggravated assaults associated with it. Because through your experience, oftentimes police officers may only charge 1 or 2 where there could be 10.
Right.
And they're bona fide charges. It's just they have enough to hold the guy. They have enough to advance it.
They don't need it anymore.
So vertical prosecution would mean I take that case from then and I bring it to grand jury. I then bring it to a trial team and I prosecute the case in trial. Again, that takes an ungodly number of people and a reallocation of resources, because then I would basically need, I would personally need 2 or 3 investigators myself in order to facilitate all those stages with multiple files. If you're talking 50, 100, 150 files per prosecutor, that's a huge number. Plus, I believe that every time you try to do that, you're teaching your people to reinvent the wheel. Because clearly, as you know, I've been a prosecutor 25 years now. Whether I'm good at trial or bad at trial, whatever that decision would be, I can do trials. Young prosecutors, when they're first in our office, cannot do what guys who at 25 years can do. So it would be counterproductive for them to simply try to learn what I know in the short time that they would have to review, indict, and then put it on a trial list. And then actually take it to trial. In my opinion, I think it's better if they learn from the beginning, which is screening, then to grand jury, then to pretrial situations. And I would advocate actually even specialized trial teams, not the teams that exist now that basically exist to negotiate cases and to get them ready for trial. But I'm talking about specialized trial attorneys that would take them. I think New York State has that.
But just, would you agree with me, though, that in an ideal world, the earlier you get involved in the case, the better view you're going to have it strategically, the better you're going to be able to communicate your view to the jury? I mean, even to the point where if you're working homicide, for example, you get a call, you go to the crime scene, you're there, you watch the detectives do what they have to do. You know, you're there at the autopsy, you watch that go on. You've seen the crime scene, you've seen the autopsy, you've met with the family, and you just take the case all the way through to trial. Do you think that gives you an advantage in terms of that as opposed to picking up a file cold?
Well, you have loaded the question by saying in a perfect world.
Correct.
In a perfect world, yes. I would agree with you 100%.
Because I have to tell you, I've seen at the Mercer County Courthouse over the years, and if you listen carefully, you can say, who indicted this piece of junk? You know, you can hear prosecutors yelling that in the hallway as they're going up in the elevator to the courtroom, and they've got a case that never should have been indicted, or it was just poorly conceived. You know what I'm saying? So,
I do.
I mean, you've had leaking bags of.
There's no question about it. But to tell you the truth, that's part of my job. I know a judge whose name I won't mention who wrote one of the seminal books in this particular situation, and he's a strong advocate of vertical prosecution. But again, that's fantastic in a make-believe world. I believe that it's entirely necessary in sex assaults. I think it's absolutely necessary in homicides. But there's only 25 homicides a year.
Right.
There
You're talking about
drug cases.
Now you're talking about murder. You're talking about vehicular homicide. In other words, any type of the death of a human being.
Yes.
That's where there's a crime involved.
Yes.
Okay.
Yes. Because thank God, there are so few of them relative to the mundane. So if you take prosecutors and you make me indict the drug case, one after another.
Don't forget the burglary.
And the burglary. Where am I going to be trying cases?
Right.
So I think that's a nice idea. Years ago, I had actually a discussion with the first assistant from many years ago, and I said, why aren't we allocating more of our time to preparing the cases before they go to grand jury, so they're trial ready, as this unnamed judge had suggested? The problem is you have to completely shift your investigative staff to pre-trial. And I'm not talking feeding trial teams, I'm talking to literally pre-trial. And where I'm going to, and thank goodness, many cases don't involve actual victims. They could be economic victims, which can be devastating, but by and large, we have to distinguish between someone steals my car outside, it's an inconvenience, it's a pain, but he didn't hurt me, and hopefully he doesn't hurt anybody else with it. It's an economic crime. I have insurance, I'll get a new truck next week. You have to distinguish that between the guy who gets robbed on the street corner or the young girl who gets molested. There's no comparison in the crimes. So you have to invest human input where you can, and then treat some of the other cases as what they really are. Some of them are simply loss of money. And again, that can be devastating. But there are certainly, most cases are not.
But it comes back, though, at the end of the day, to the responsible use of prosecutorial discretion by the county prosecutor in light of the seriousness of the crime, the societal issues involved, and preserving taxpayer resources. I mean, that's really what it comes down to.
Yeah, and one of the things that I enjoy most about my job, and most people don't realize this, because we do have to run serious decisions past our supervisors, depending on our level of seniority in the office and our experience.
Right.
But I have a tremendous amount of discretion. And even when I have to get permission to do something from somebody, so it's not totally within my discretion, I still have the ability to express that position and that opinion, and it's largely accepted by my supervisors.
But that seems to me to be a function of assistant prosecutors on the county level throughout the state. I don't think that the Deputy Attorney General staff has anywhere near that level of independence or discretion or freedom to act. I think
I've heard that, and
I think it's a much more political tradition or culture at the Attorney General's office as opposed to local prosecutors' offices. I mean, that's what I hear.
I can only imagine if in the sheer number of cases that I've handled, if I ever had to type up a 3-page summary, I can't type.
Right.
So that alone would take me half a day. But the AGs run on a different process, and often in totally different kinds of cases as well. They don't usually handle the day-to-day crimes that we deal with in the prosecutor's office. I think our supervisors invest a great deal of what's the word I'm looking for? Trust in our opinions and in the years that we've been there. Now, not every prosecutor in my office is allowed to negotiate an armed robbery. The younger prosecutors are not even allowed to handle those kind of cases.
Nor should they be.
The older ones, naturally, they migrate towards the older prosecutors because we handle the more serious cases, and our discretion is generally more widely accepted among our supervisors.
So let me put it to you then. Let's go back to our theoretical case, not the shoplifting case, but somebody who's committed, either a first or second-degree crime. All right. So you got the file, however you get it. Doesn't matter whether it's horizontal or vertical. There you have it. It's in front of you. You're the assistant prosecutors in charge of presenting cases to the grand jury. And I really have 2 questions for you. Number 1. Assembling the grand jury, well, it's really 3 questions. Assembling the grand jury, instructing the grand jury on the law, and then finally presenting your case. So can you kind of talk about that?
Sure.
All right. Well, first of all, just in terms of getting the grand jury kind of assembled from the public.
The grand jury is chosen from a pool which is statutorily defined as coming from various areas. I think it's driver's licenses, voter records, and a few other car registrations, I think. It's a pool of people, and then they assemble in front of either the assignment judge or the presiding judge or whoever.
Presiding criminal judge.
Yes, whoever's designated for that role. In our county, Mary Jacobson obviously is the head judge.
Mercer County Assignment Judge.
Yes, she's deferred previously to Judge Counsel, who then would instruct the grand juries. As you know, I think it was January 1st of 2007 is when the actual, when literally the script, if you will, that the judge, the instructing judge, had to give to the assembled masses prior to their selection in grand jury. So he would give that information as pettit juries are given that type of information. They get it, though, through a television screen and through Judge Jacobson as well. It's similar. And they're instructed on what their behavior is and what's the difference between a pettit jury and the grand jury. And eventually, 23 names get called out, and if they're not disqualified for some reason or don't come up with a reason why they should be exempted, they get chosen to sit. They sit for, I believe, a period of 3 months in total, once a week. And they make decisions on any given case. We have had, I think, as many as 4 grand juries sitting at one time. Simultaneously.
Now these are Mercer County grand juries. These aren't necessarily state grand juries. In other words, grand juries run by the Attorney General's office.
That's correct.
Right.
To tell you the truth, I have never personally seen a state grand jury sitting in a Mercer County court.
They may be over at the Justice Complex.
I think they are. But that, of course, they have jurisdiction statewide. And our jurisdiction, we can indict anything from our county outward in any other county if we choose to.
Sure.
But generally speaking, we do not. We do Mercer County.
So we've got 23 people now that have qualified. They're sworn.
Correct.
They are going to hear evidence on cases. They meet once a week, usually.
Yes.
Over a 3-month period. That's their, or whatever the course of their term is. And every week there'll be a certain number of cases presented to them depending on, how much work you have in that particular week. Mm-hmm. Typically in one session, how many cases can you present?
Gosh, I haven't been on grand jury actively in a number of years, but I think we used to do about 20 or 25 a day.
Right.
That is absolutely variable, anywhere from 2 to 30, depending on the complexity of the case. Actually, how young the grand jury is, so to speak, how new they are. New grand jurors are often asking constant questions about legal principles and legal terms that they often then become familiar with and don't have to re-ask. So the first day, 2 cases. By the last day, they may be handling 25 or 30 because I don't have to stop and redefine terms that they already now know.
So there's definitely a learning curve associated with that.
Oh, a huge learning curve, because unfortunately most people are told or learn through the criminal justice system, which is good. because usually you only learn it either being victimized, being a juror, or being a grand juror, or actually being an arrestee.
You left out going to law school. Now, they're over and above the initial instructions given by the assignment judge or the presiding judge of the criminal part to the grand jury. That's more like a welcome than anything else. Ultimately, it's the responsibility of the assistant prosecutor, though, to instruct the grand jurors on the law.
Yes.
And this will mean instruction on concepts that they've probably never thought about or heard about, such as culpability, what it means to act purposely, what it means to act negligently or knowingly, explaining what possession is, explaining what bodily injury is, serious bodily injury is, sometimes explaining what death is, That's part of your job as an assistant prosecutor?
Yeah, that's probably some of the most challenging, because most people hear their definitions of legal terms, again, from television or movies. And what they learn from television and movies is usually completely inaccurate. The word possession you brought up. What is possession? Are you in possession of your ring? Yeah, because it's on your finger. You know, of course, this. I'm just saying this for the audience. But the pen next to you, are you in possession of it? You're in control of
Constructively,
it.
I guess.
But that's a term that, believe it or not, is very difficult for them to initially grasp. But by the second or third week, they understand exactly what we mean.
But it's broader than that in the sense that you're going to have to give them the elements of theft. You're going to have to give them the elements of fraud. You're going to have to give them the elements of, assault. Just anything that's going to be coming up, you have to instruct them about what those elements are, right?
Yes, and one of the key ingredients and one of the most difficult parts of grand jury is to make it more efficient. We try not to re-instruct on identical charges. So, for instance, on day one of grand jury A, they may get an aggravated assault. We define aggravated assault. We then keep a record that we have already defined that term to that grand jury, so that the next time an aggravated assault is presented, that we then usually, as a matter of course, will say, does everyone understand the charge of aggravated assault? You had it in week 1. Does anybody need a rereading of that statute?
Well, let me ask you about the fairness of this. I want to play devil's advocate for a second. I mean, the instruction, generally speaking, is going to come fairly early on in the history of the grand jury. You agree?
Yes.
All right. So you've spent a significant amount of time as an assistant prosecutor instructing them in the law. And now a case comes up 70, 80 days later, and they've got to put these principles together. But these are people meeting once a week. They're not lawyers. These are lay people for the most part. I hope they're not lawyers. And is it fair to expect them to understand the nuances of the law that they were instructed on once such a long time ago?
I mean, when we indict, as you know, the indictment itself is basically a reduction, if you will, of the statute. It repeats, Joe Blow stole a car on this day. That is probably 70% of our work. Those uncomplicated types of situations. So we have initially instructed them what does it mean to possess? What does it mean to deny possession? What does it mean to take it for a limited period? Joyriding. What does it mean to take it
permanently deprive the individual?
Permanently deprive. So those kind of concepts are often repeated frequently, and they're actually basically repeated in the physical indictment themselves. Usually the indictments, they're not trickery. Okay. They're pretty simple. Did commit a sexual offense against X by any nasty means you can imagine, but that's usually included in the indictment. And if the grand jury has any questions whatsoever, they raise their hand.
How do you, as an assistant prosecutor, though, make sure that you're properly giving them the right instructions? Does the Attorney General give you what these should be, or is there some master book that has all this stuff, or you just pretty much go to the code, the criminal code, and...
Generally speaking, we read it literally off the statute, right off the statute. Now, we may get a question from the grand jury during a break, not a break, but when we go off record, and sometimes they will ask us a question that they want us to ask a witness. It has been my experience. I haven't sat on our grand jury in a while, but it's my experience. We generally do not let the grand jurors directly ask questions to the witness.
Why is that?
Because sometimes they may ask a question in a form that is either inaccurate, misleading, or it may lead to the police officer interpreting it in such ways that he gives information that would be otherwise inadmissible or inappropriate for the grand jury to hear.
But who's directing the grand jury? Is it the foreman of the grand jury or the assistant prosecutor?
What do you mean by directing?
Well, no, it's ultimately who's responsible for the investigation of these cases. Is it the assistant prosecutor? In other words, the grand jury could the grand jury or the foreman say, "Listen, we want to hear more evidence. We want to hear other witnesses or something."
That's happened to me many, many times. Right. Absolutely. I can only speak to what I have done and the limited number of transcripts that I've read from other people, perhaps on appeals or something. But my procedure, it was always, after you read them the indictment, normally you would discuss the indictment informally, as you may know. We generally give them a rundown of what we anticipate to show them, so that they have an understanding.
So your office has drafted the indictment ahead of time, the raw language in it?
Yes. Normally we almost always do that.
Right.
However, if there are certain circumstances where we think they may interpret something another way, such as you've already talked about, they don't believe it was knowing and purposeful. They think it was reckless. Mm-hmm. On those occasions, for instance, in an arson case where that distinction is huge, I would have prepared alternatives in the indictment, and that I would be explaining to them so that I would not hold them up. I would then ask them to reach perhaps a decision halfway through. Go off the record, discuss. Are you people reaching a decision whether this was purposeful or was this reckless?
Let's look at it in the context of a homicide case. So you're talking about the difference between murder and manslaughter.
It can be.
Or aggravated manslaughter.
Sure.
So at that point, you go through this procedure, stop, you would leave the room, and they would deliberate, correct?
No. I only have to leave the room if they request me to leave the room.
Okay. But you don't participate in their deliberations,
I do not participate in deliberations at all. I'm there. I can obviously hear them talk. Right. If something inappropriate comes up, I would go back on the record immediately and say, I have heard something. I have not heard. I'll just use an example of something I've not heard. But if somebody were to say, I'm Polish, so I'll make fun of Polish people, that Polak can't be trusted. Mm-hmm. I would immediately go back on the record and say, Assistant Prosecutor Matthew Rogulski, I think I've only had to do this once, where I said there's inappropriate discussion taking place in the grand jury regarding an inappropriate topic. I have cautioned the grand jury that topic is inappropriate for this purpose.
And of course, this is totally consistent with your obligations under RPC 3.8. You're there to do justice. You're not there to merely secure convictions.
Oh no, I'm not talking about a fact. I'm not talking about, oh golly gee, I'm going back on the record, that guy killed a man. No, I'm talking about if something inappropriate was brought on the record, and it's only happened once or twice, I'd gone back on the record and made the correction in one book, because it usually is indicative of a misunderstanding by the grand jury of what the case may be generally about.
I think my main concern here is just to kind of separate, though, the limited function of the assistant prosecutor, because ultimately the indictment's got to be as a result completely of the deliberations of the grand jury by themselves.
Absolutely.
You're not supposed to be in there, kind of holding their hands as they do this, so to speak. It's got to be from their deliberation. It's their verdict, not yours. That's what I'm trying to say.
Oh, absolutely. But one of the things that I constantly faced is, as you're saying, I present my case. I ask them, do they have any questions do they need additional witnesses? If they want additional witnesses, absolutely. I'm free to call them. They may not be outside, but we just hold over. And the foreman is free to speak to me. They're free to speak to me on record and say, I'd like to, or they'll address the foreman most appropriately and say, I'd like to hear from the second police officer. My response to that would be, absolutely. Not to debate them, never to say, oh, you don't need to. He's going to say the same thing. Nothing like that. It's simply say, if you wish me to call him, I'll call him. It's that simple. But the biggest problem is the grand jury sometimes confuses deliberations with questions to me. So they'll deliberate.
Can you use an example of that?
Sure. They'll deliberate about, do you think the ID was good enough? Did the police officer or the witness?
In other words, they're asking you to be a witness.
Oh no! I'm talking about, they're talking amongst themselves.
All right.
They're talking amongst themselves. And one person will say, I don't think that ID was good enough. That was dark outside. And someone else will chime from the back. No. There was testimony that there was bright light on. And that the front guy will say, no. There was testimony that there was no light on. It was total darkness. And then they'll look at me and they'll say, okay, what are we doing? And I'll say, before I say anything, I say, we have to go back on record. And generally speaking, I would say a grand juror or the foreman has addressed me with the question. The question is, was there a light on or not at the time of the identification? Mr. Foreman, would you like me to recall the witness on that question?
You're not going to remind them of what the testimony is because that's not your function.
No, that's not my function. But I can certainly tell, I can't speak for anyone else, I have said there has been, to the best of my recollection, there has been testimony regarding whether or not there was a light on. Mm-hmm. If you would like me to call that officer back in to go over that issue, which is a seminal issue in an ID case, obviously,
sure,
I'll say, be happy to. Silence, then I go off the record, and oft times, 99% of the time, they all say, we don't need to hear the guy anymore. And amongst themselves, not to me. We don't need to hear better. This is silly. I remember now the testimony of the police officer. He did talk about the light. Well, I will not tell them the fact, but I will tell them that the issue was discussed. And if they need clarification of the issue, whatever the clarification was, they can have it by having the officer back in.
Now, let's just kind of clarify what we're talking about. I mean, do you explain to them that ultimately an indictment is going to rise or fall on the vote of 12 of them, that there is probable cause to believe the offense took place, or is there some other level of belief that they have to have in order to return an indictment?
That's it.
Do you instruct them on what probable cause is?
Oh, absolutely.
What do you tell them? I mean, just off the top of your head. Do you explain to them that it's a well-grounded suspicion or things of that nature?
The standard definition, which I could blurb out to you now, but yes, it's a well-rounded, well-founded suspicion. I've forgotten the actual definition. I've never instructed a grand jury, so I don't know what the words are that they're told.
So basically I know in Mercer County there was one guy who was there for 4,000 years who was just an expert on instructing grand jurors, and that's all he did all the time. There's some very smart grand jurors in Mercer County because of him. But the bottom line is, and I want our viewers to understand this, that we're talking about, in the grand scheme of things, an extremely low level of proof. It does not take a whole lot it should not take a whole lot of evidence to persuade grand jurors that there's probable cause to believe that X committed this particular offense, especially when you're looking only to have 12 of them. You know what I'm saying? Do you disagree or agree?
I disagree with your choice of words.
Good. When you
persuade, I don't persuade anyone. That's not my job in grand jury. As you know, if I have evidence against my case that would hurt my case, I'm duty-bound to present it.
Correct.
And I do present it. I have to. Otherwise, the indictment means nothing. Mm-hmm. It'll just be dismissed, and that'll create a huge mess, and it's not appropriate for me to do that as a prosecutor in the first place. It's not my job to waste everyone's time by being silly and trying to get around the rules like that, because eventually it will get caught anyway. But beyond just being caught, it's inappropriate for a prosecutor to do that. I absolutely would present any information pursuant to the rules that would exculpate the defendant. I leave that entirely up to the grand jury as to what weight they give or don't give. A lot, there's the old phrase, I can indict a sandwich.
I was going to ask you about the ham sandwich.
I think that is often used by attorneys who are defending clients.
It's used by defense attorneys all the time.
Are you making usually public statements in front of large cameras and microphones, and they're trying to get press time? I have not come across a stupid grand jury. I have not personally done that. Maybe there are. Maybe I haven't seen them. But the grand jurors that I've been in front of have asked a lot of piercing questions.
Well, have you had situations where they no-build a case? that you felt strongly about? Or
That
the
I
evidence
felt
was-
strongly should have been indicted?
Sure.
That's a good question, and no. I have certainly had cases that I thought were absolute 50-50, could go either way. And most of those kind of situations are word against word cases. And then you're into situations, you're into family relations, you're into all these things that are part of the stew. And it's my job, quite frankly, on occasion, I certainly have presented cases personally where I didn't know the answer either,
Nobody
but
knows
that's
the
not
answer.
my
but
job.
but nobody knows the answer, okay?
Well,
And
there
nobody-
is one guy that knows the answer, but he ain't talking.
That's right. But here's the thing. I mean, it's not the grand jury's job to figure out this is not a search for the truth. This is a search to see just is there sufficient evidence for us to charge this individual. You know, pettit juries are going to make the decision of guilt or innocence.
Well, again, it is a search for the truth, because if they have reason to believe that I'm not telling them the truth or that a witness is lying, then they should reject the indictment.
Got it.
But so I understand the words you mean, and I know you're not. I know you're not trying to be.
For one of a bit
Flippant
a wise guy.
with the word. No, but each word, of course, is important. That you say that I have to agree or not to agree to. It is a search for the truth in that sense, but it's only a proof to a certain level. It's not proof beyond a reasonable doubt.
I'm going to throw some monkey wrenches at you. You know that. You know
Sure.
this is coming, so get ready to start ducking.
You can dodge a wrench, you can dodge a ball.
All right. So I don't want to get too high in the weeds here, but let's go back to the ham sandwich for a second. All right. If somebody said to you, an experienced prosecutor could get an indictment on anything and anybody on very, very little evidence, you would disagree with that?
That's just hyperbole.
Okay. That the grand jurors that you appear in front of are intelligent people and they ask a lot of hard questions and they're demanding.
Well, let me put it this way. Out of 23 people, there could be guys who are less bright than the others. I've had college professors. I've had college professors who debated me and others on every word that I uttered or that of a witness ever uttered. I mean, every word. I've also had college professors who sat there and nodded as the guys testified.
Right.
It depends really on the case. It's absolutely, and the ham sandwich thing, that's just for public consumption.
Let's go back to talk about, you mentioned, and it seemed to me it came up in the context of sexual assault, where you have two completely diverse ideas, and I guess the defense is going to be consent, assuming that a sexual contact took place. Let's talk about the circumstances under which a defendant would want to testify before the grand jury. All right. In fact, the attorney on the other side is insisting upon it. I want my guy to testify. My guy wants to testify. He wants to tell the grand jury his side of the story. Now, let me just kind of set this up a little bit, because with my brothers at the defense bar, some of them, like our friend Lindsay Burbage, Lindsay just took the position his whole life as a defense attorney. I will never have my client testify for the grand jury. And it was very simple. That's it. He'll never testify. That's the way it's going to be. Other attorneys, like Joe Rem, for example, he and I were just went over this the other day, and there are cases where he does want his guy to testify. And every time it's happened, they no-bill the case. I've only been confronted with this once in my lifetime. They no-billed my guy. He was able to talk his way out of it. All right? But I've also run into assistant prosecutors where you write a letter, say, look, my guy wants to testify, and they say, well, we're not calling him. He can't testify. So what's the rule here? What's the dividing line? When does the defendant have a right to testify before the grand jury? And when is depriving him the right to give his side of the story to the grand jury really a denial of due process or appropriate?
That's a good question. I honestly don't know the answer to that. I don't believe he has a right to testify in front of the grand jury. I could be completely wrong, and if I am, I expect you to edit this out.
Well,
but
I don't think you do have a qualified right to do it, but by the same token, if all you're going to do is deny before the grand jury that you did it, well, you can do that just as well at trial. Because, again, this is the function of the grand jury is basically not going to be advanced by you denying that you did it. But if you have evidence to give that could be significant in the case, I think you have a right to testify.
Well,
what would you do? What do you do when you get these requests? I'm sure you've had attorneys say to you, "I want my guy to testify."
That's only happened once.
All right. Well, maybe it doesn't happen all that often.
To me, that's happened once.
Right.
And quite frankly, he came in, and I began asking him questions. Gosh, this was years ago. And he literally started cursing at me. Then I mentioned that he would be held in contempt of the grand jury and that I would drag him downstairs to, I can't remember who the then presiding judge was. And he then continued to curse at me, yell four-letter words at me as he walked out of the grand jury.
Did that endear him to the grand jurors?
It did. It did. It took them almost 30 seconds to indict him. He didn't further his cause whatsoever. Needless to say, when you go into a grand jury, you have no attorney sitting next to you. You have nobody advising you. You have nobody invoking. In fact, you've waived your fifth. You have nobody telling you what you should and shouldn't answer. And generally speaking, you are not trial prepped. You may think you are, but depending on how much time you've already spent with your attorney, that may not be a great amount of time.
So the limit,
and it also depends, quite frankly, if you're innocent or not. Mm-hmm. Now, I know that's with prosecutors that I think that concept is taken much more black and white than it is with defense attorneys who always go, well, you never know, and you never do know what your people are telling you. I'm sure as a defense attorney you've been lied to 1,000 times.
I didn't pay attention.
You're clearly not as handsome as me, regardless of what
you know what, I'm serious about this. I don't pay attention because it's irrelevant what they have to say.
It limits your defenses. But the point is, if you have a guy that's very believable and you believe that, and that you believe, I know you'll never know, but you believe that he is innocent, taking him to grand jury, I don't think is going to hurt. Because I rarely, on the one occasion where I did it, I began to cross-examine the guy. And an unprotected cross-examination can be very dangerous. But if you have a guy on a simple case who's going to simply walk in and say, golly gee, I'm telling you, I went out with that girl for years, I don't know what to tell you. That's what he's going to say at trial anyway.
That's the whole point I was going to make. He has a story. He's going to stick to it. He has to testify. He has to testify at trial. So it's the downside of taking a shot.
Oh, he doesn't have to, but I understand practically.
As a practical matter, he's got to testify at trial. All right. In order for him to pull this off, the pettit jury has got to hear his story.
So if he sticks with A, B, and C in grand jury, and I can't shake him, and I can't, because my job at grand jury is not to shake him. My job as a prosecutor, they use the word adversarial system. I have never thought that was a good description of my job. I am not your adversary. I am not the adversary of the defendant or the defense attorney. We play a game, and on game sides, you often think, oh, they're adversaries because it's a game. I've never thought it was a game. My job is to look for the truth. If the truth is your defendant should walk, then that's what I should be looking for. And I have had cases like that where I called the timeout and the case was over.
So for the young attorneys who are watching this, I just want them to understand conceptually what the situation is going to be. If you are in a situation where you want your client to testify before the grand jury, you're going to write to the prosecutor's office, and that's the person you write to. You don't write to the foreman of the grand jury. You go directly to the county prosecutor's office.
Sure.
There's a Supreme Court case on that. Then, assuming that you can get by that, they want your guy to testify, you as a defense attorney will be there. You'll be outside the grand jury room. You tell your client that he'll be instructed that he's waiving his right to remain silent by the assistant prosecutor, and that anything he says can and will be used against him, not only here, but also at trial if he makes any admissions. He will be permitted to leave the grand jury upon making requests to either you or the foreman to come out and answer questions related to his testimony. But again, he's going to have to go back inside without counsel there and be subject to any type of questioning by either the grand jurors or you that that they think is appropriate. The key is this is going to be his only shot to tell his story to the grand jury, and you've got to make sure he's ready to roll. I mean, he's got his story down and can articulate it in a way the grand jury's going to understand. I mean, do you agree with all this?
Yeah, because I really do believe there is a difference philosophically, if you will, between a pettit jury and a grand jury. I don't, in my opinion, based upon my experience, I don't think grand juries are looking for a trial prosecution. They are looking for an exploratory situation. They want to know as much as they can about a circumstance and make a decision. Should this go further? Should we put him in jeopardy? Trial jurors, to me, are always different. Their decision is much closer to jeopardy, and I think they want a different level. That everything's amped up. This is trial now. This is not grand jury. This is not one-sided. This is not the prosecutor who says or does this. This is now all amped up. So, if you're asking me, is it wise? It's only wise if I believe, if you have a client that you are convinced is innocent, that the charges are relatively uncomplicated and he can answer questions, right, basic questions, that he won't get flustered unnaturally, and that he's willing and able to repeat in trial. Because if he has a massive record and he can't come back into trial because he can't take the stand, then what good has he done?
None. But the other thing, there's something else too. And this is really based on my own experience dealing with this and advising other attorneys. I really put a lot of the determination whether I'm going to do this on the assistant prosecutor who's presenting the case. Because if it's somebody who I know is fair and will let the guy tell his story and let him at least get his side of the story out and will walk him through it before he starts to cross-examine the guy, for want of a better term, all right? In other words, facilitate the guy telling his story. And many times I'll meet with the assistant prosecutor ahead of time and I'll say, look, this is my guy's story. This is what he wants to say. Just ask him questions along these lines. Let him say what he has to say and then do your job. You know? Because if I had a guy who I thought was a fire breather and was not going to be fair with my client, and by the way, assistant prosecutor can do whatever he wants in there. Okay? He's unrestrained in terms of what he's going to do.
Leading questions? Of course.
There's no judge in there. There's no hearsay rules. There's none of that stuff. So, okay.
No objections, no let my client answers, nothing. So that guy is basically got to have his story tight.
But you've got to have a prosecutor who's going to be fair. I mean, you really do. And you've got to trust your instincts that the assistant prosecutor is going to be presenting this information is going to do so fairly.
I agree entirely with what you're saying. Is you got to meet the prosecutor beforehand, explain to him what your client's position is. Obviously, what you're telling us is not admissible against your client. So you're giving us a proffer of what he's saying. Right. We understand, and then we can put it in the context of the case. Because sometimes, one thing that's always amazed me is defense attorneys who don't give defenses until trial. If your client has a bona fide defense, I'm the first guy you should tell.
Yeah, and this is something I was thinking about it when you mentioned the word, this adversarial stuff, which you don't like. I don't like it either, because I don't regard the criminal justice system as adversarial. I regard it as collaborative. I mean, the people that I deal with at the prosecutor's office, we just are not adversaries. We have a job to do. We have different jobs. And in that sense, we're adversarial, but we work collaboratively all the time. Because look, the assistant prosecutor looks at a file, an experienced person. He knows what the case is going to be at the end of the day. I look at a file. I know where it's going to be at the end of the day. And many times we're very close. It's just a question of getting to yes. There may be a little horse trading, so to speak.
Yeah, but you are a ridiculous exception to the rule. Well, your negotiating skills are second to none. And I've experienced them. I've seen them in action. By and large, most attorneys are not like you. First of all, they don't have the years that you and I have. And you and I...
That's nothing to be proud of, by the way.
Well, it beats the alternative.
The point of all this, though, is I think if you go in with the attitude that you recognize the responsibilities of the prosecutors ethically and otherwise to do justice, you realistically look at the file, you understand your adversary's job, you understand your job, you work collaboratively to get to a result in the case, okay? And then if you can't do it, you try the case and the chips fall where they may.
My job is not win or lose. I try to impart that to the young prosecutors. Our responsibility is absurd. We talk about numbers. In the civil law, you talk about numbers. Oh, how much your client want? 100 G's, 200 G's, 500, whatever it is. Usually it's insurance money you're bouncing around. So the money is hypothetical. We throw years around as though they're not, oh, you take $2 for that pair of shoes, $3. No, these are years of people's lives.
And so often I'll be sitting at home and I'll be watching something on TV, and the guy's charged with all these horrible crimes, and at the end, I'll tell you a perfect example. I'm watching a show that's called Homicide Hunter. It's my favorite show, okay? And they go through the whole hour showing how the guy was investigated, prosecuted, and then they tell you his sentence at the end of the thing for some horrible homicide crime. And many times I'm saying to myself, hey, that guy did good. He did 7 years. He did good. Kind of ignoring the fact that 7 years out of a guy's life is a long time. But then, when you're looking at doing 45 with parole and eligibility of 40, the guy gets 7. But as lawyers, this is what we, it's crazy how we think about this stuff.
Yes, because the numbers, until the door locks, the numbers mean nothing.
Sure.
And, the system would be a lot more efficient if the defendants understood that.
But I mean, you've been in this situation where you look at somebody who's getting, out of context, it looks like a lot. When you see but you contextualize, you say, that guy did pretty good.
Yeah, it's crazy because I know me, and I can probably speak for you about an hour and a half behind. You interview clients, and you probably get the jitters when the door closes. It's a horrible, horrible, horrible place. The prosecutors, they want to do their job. They have to understand that we're.
Now, you're talking about jail or the prosecutor's office?
Well, the building isn't so high.
I walk out of there. I'm always afraid the brick is going to fall on my head.
You can sue. I can't.
I want to just. There's one grand jury issue I wanted to touch upon, and that deals with the quality of evidence in the sense that, there are no, as we mentioned before, there's no rules of evidence, okay, and you're going to put as much evidence in as you need to get an indictment. But what are the limitations on the types of evidence? Can you base an indictment on pure hearsay? How close do the police officers involved in the process have to be to the actual real events? How much hearsay can you rely upon? How much live testimony has to be there? Over and above what it takes to persuade the grand jurors. As a matter of law, what are your thoughts on that?
I knew you were going to get to that question because we talked about it a few days ago. Unless I'm mistaken, as I get older, I'm more want to make mistakes, but I believe there's still those two competing appellate division cases that had been coexisting for 1,000 years. And you probably know the answer to this. One was saying
I'm just trying to
you couldn't rely entirely on hearsay. The other one said you could rely entirely on hearsay.
It's the residuum of evidence rule,
which is
basically you just can't have 100% hearsay there. You got to have something there where somebody's actually has personal knowledge about what happened.
Well, I guess that was the synthesis of the two theories. In any case, that's exactly the one I go by and the one my office goes by. We can't possibly, in a timely fashion, involve or engage in an indictment situation or a proceeding where we're bringing in non-hearsay witnesses. We bring in 10 witnesses to establish what?
You're lucky to get these cops to show up at all.
I have no comment on it.
Nor should you.
But I do my best to get an officer who is a witness in some context.
Right.
So he may not be the detective, because let's face it, you pull those detectives off the street and you sit them down in grand jury for 4 hours. They're not on the street for 4 hours. That is definitely something we're aware of.
But you also have the opposite side of the coin too. Is look, if they have a story to tell, you want to have them tell it one time under oath, not 3 times under oath, because he makes a statement here. The least little thing he says at trial that is consistent with his grand jury testimony. Oh, well, hey, the attorney's going to jump all over him.
My job is to present the truth, not to paint it, not to warp it. If he says the car is gray, and then the next day he says it's silver, or 3 years later in trial he says it's silver, and I personally don't believe that there's any distinction and he's not lying, I have no problem with that. And if he gets hit with that, he gets hit with that on cross. I've already prepped him anyway. Right. By prepping him, I'm not telling him what to say. My point is, I'm telling him, hey, you said it was gray here in your report. You said it was silver. That's going to come up because I have the grand jury transcript. I know when an officer is making a mistake because I sit there with his reports in front of me in grand jury. I will often say, officer, allow me to refer you to your report. Didn't you indicate that car was red? And he'll look at his report and he'll say, yes, the car was red. Thank you. Because many of these officers are, he's just done 2 arrests before he shows up in grand jury. He's done 50 since this case happened 2 months ago, if it comes that quickly before the grand jury. So his ability to remember, especially, my favorite is car chases. Help me out here. Eludings. Eludings are wonderful when they last an hour. By wonderful, I'm being facetious. We'll get the police officer, and he's trying to remember street after street after. Now, I can't remember the streets, and he's giving me this, and I'll stop him and say, wait a second, you have a report. Is the report true when you wrote it? Yes, it was. Will it help refresh your recollection? Yes, it will. So I'll back him up, and then he'll go street by street by street. Now, if I thought he was making this up and lying, boom, time out. I send him home. I talk to my supervisors. That's how I see my responsibility.
Well, from a tactical standpoint, though, do you want to present to the grand jury enough evidence to return the indictment, or do you want to do overkill?
You don't have time to do overkill. It's a matter of practicality. If I were to call every possible witness that I would normally call at trial for a simplest drug case, you have the surveillance officer. You have probably the arresting officer. You have his partner. You have the guy who took the drugs. You have the lab guy. You have the expert, right? Then you have your own detective who handled chain of custody. Mm-hmm. Now, I know chain of custody under State versus Brown. I haven't proven chain of custody in 25 years because you don't have to under case law. But theoretically, I would call, did I count out 6 or 7 witnesses? All of whom would be sworn. All of whom would I have to go over the report. All of these basics. How long would that take? An hour and a half, 2 hours?
Well, and plus, they're all government employees, which means it's time away from their normal functions while they're waiting around all day to testify.
Can you imagine me having an entire cadre of what was proactive sitting in, now, if I smell that something's bad here, it's my responsibility. It's what I swore years ago. I smell something in the cheese, I stop it, and I back out.
We've talked about the grand jury in its accusatory sense. Mm-hmm. I'd like to switch over to the other traditional component of the grand jury, the traditional function of the investigatory component of it. In your county, do you ever, when police are out working an investigation, would you ever supply them with blank grand jury subpoena forms so that if they start getting resistance by people out on the street, rather than get into some kind of confrontation, they would just say, okay, well, you can either tell me now or here. You can come down and talk to the grand jury. Do you ever do that as an investigative technique?
I have never done that. I have never needed to do that, nor am I aware that it is actually done. If it is done, maybe it is, but it's never been part of any assignment that I've had with that kind of spontaneity involved. I certainly have had detectives generate subpoenas, returnable, of course, on a grand jury date.
Right.
But they do that always. They're getting this record, that record, this record. They need this, that. That's a matter of investigative technique that I often don't even get involved in, other than to say, get me that record.
All right.
But so with Sponte, I don't know if it happens on the field, but I guess it could.
So, have you used the grand jury yourself in a professional capacity for investigative purposes? You got a case that the prosecutor's looking at conduct by a governmental agency or something of that nature?
No, I haven't. I've generally been a trial attorney most of my career there. Right. I've been in charge of certain units, but they weren't investigatory units. They are, like arson, economic crime one time, at one point in my career. Arson, I used the grand jury quite often. That was where we talked about earlier about the alternative indictments. I had 78 original counts. And I had to make 78 because during the presentation they were going to have to say, was this on purpose or was this negligent?
Right, so you have 4 now.
Boom. And it went down to 40. Then it went down to 20. Then it went down to 10. And the 10 were including, attempted murder. Right. But I had to prepare 78. Otherwise it would have taken weeks, to come back and come back and come back.
The function of the grand jury as an accusatory, as an investigative body, though, is one of the traditional functions of the grand jury, and it need not necessarily be for criminal conduct, in the sense that the grand jury may look at a situation. This is typical for governmental or some political subdivision of this state of New Jersey, and utilize its power to make a determination as to whether there's been misconduct, but not necessarily criminal misconduct. And maybe it may not be.
Misuse.
It could be
abuse.
misuse.
Sure.
It could be a million things. all right?
Nonfeasance, malfeasance.
Right. And typically, if there's criminal misconduct, the grand jury would return an indictment and thereby formally charge whoever the target is with the commission of a crime. Now, the thing is that an individual who's been named in an indictment has a way of vindicating himself or herself, and that's through trial by jury. You have an absolute right that no one will take away from you or can take away from you to a trial by jury once you've been indicted in New Jersey. That's just the way it is. You get indicted, you have the right to vindicate yourself publicly in a courtroom before a jury of your peers. But if you have a presentment that comes out, presentment is not a criminal charge. It's more a report and findings by the grand jury of misconduct. And there could be allegations of misconduct by individuals contained in the presentment, and there is no mechanism under New Jersey law to vindicate yourself. So if I'm accused in an accusation, in a presentment returned by grand jury of some type of misfeasance, malfeasance, whatever it is, it didn't rise to the level of criminal conduct, or maybe the statute didn't run. It could be other reasons. I don't really have any way of vindicating myself publicly from these allegations. They're going to be out there forever. So the only alternative I know of, and there may be others, is that you go to the assignment judge, and before the presentment gets released, you seek to have your name redacted from the presentment, because again, there's no mechanism for you to challenge it publicly. You can't vindicate your innocence in any way when you just, you're kind of highlighted in the presentment.
I don't know where, quite frankly, I've not been involved with one of those.
Thank God for
I've
that.
not even become aware of one of those, other than through the newspapers. Like there may have been one or two ongoing in my career with the grand jury, but that's generally the value of the state grand jury. Mm-hmm. That's where they make their money.
Right.
They're massive investigations. They have virtually, compared to us, they have virtually unlimited resources as compared to the feds, to the state. The feds have unlimited resources. So they can do those kind of investigations. I guess, depending on what the nature of the allegation would be, your method might be in your own investigation, unfortunately, funded by you to counter the allegation. Depending on the nature of the allegation. But for instance, if they say that Public Works isn't stopping leaky fire hoses.
That's exactly what came to my mind. I was thinking about the waterworks, okay? So you have allegations of theft or fraud or something of that nature among employees at the waterworks. So the grand jury is going to return an indictment against these individuals, and their cases are going to go to trial for misconduct or whatever it is. But the grand jury may also come back with a presentment saying there were very loose accounting procedures and supervision procedures which facilitated this, and that was done by this guy, this guy, this guy. So the conduct is not criminal, but yet the presentment criticizes individuals and makes recommendations for changes in the future.
Right, and they're not subject to lawsuit for defamation.
No, of course not.
Because they're public. It's a public situation.
Of course. So, to me, this is really the kind of that typifies the investigatory component of the grand jury traditionally. Okay.
Yes.
So I'm glad you haven't been involved in those things in the past, but I want our viewers to understand that the investigative nature of the grand jury is not only in the criminal context, but also kind of serving the public, so to speak, with the return of these presentments.
Right, because they have tremendous subpoena power. That's probably their biggest. That's their biggest weapon. Right. We talked about briefly before. My subpoenas for any kind of records are in the name of the grand jury, so to speak, and returnable on a day that they're sitting. The state grand juries or the investigatory grand juries have tremendous subpoena powers that, absent probable cause and search warrant, states can't get, police can't get.
Let me ask you this. When you have people testify before the grand jury who are potential targets, does you ever have the situation come up and you notify them that they are targets?
Oh, yeah. There's a protocol. There's actually written out instructions that have been disseminated. I think it's on the website itself. You have to read them, their target instructions. That's what they're specifically referred to as, outline their rights, their abilities. You have to warn them that they can't just decide what questions. The biggest warning to me is they can't decide which questions they feel like answering.
So it's an all or nothing proposition.
Correct.
They're either going to testify or they're not.
The case I told you about a little bit earlier, he would only give me his name and the fact that he wasn't guilty. They were the only two things he was going to answer. And it was a while ago, but basically that's all he would do. And I would say, sir, you're not here to give us your opinion. You're here to answer questions. You've waived your rights, and you're now subject to my questioning. And he didn't like that. He just thought he was going to actually come in, say his name, and say, good morning, everybody. I didn't do it, and then leave, which caught me by surprise. But that was the only time we've ever had anyone come in and want to testify.
Now, for the very, very young lawyers who are just undertaking the criminal practice as part of their career, I just want to spend a couple seconds talking about accusations, because we discussed before that the idea of indictment is an indispensable component of the charging process in New Jersey. It's a constitutional right. But you do have the right to bypass that procedure also, but there has to be some type of charging mechanism to get you, in front of a Superior Court judge for the purpose of entering a guilty plea and being sentenced. And just a complaint is not going to cut it. So the substitute that we utilize in New Jersey is an accusation. An accusation is really just a substitute for an indictment, a quick way of waiving your right to have the matter presented to the grand jury and having them consider your case and returning a formal indictment. It's really kind of a shortcut, I guess is the best way to say it. But I don't want to downplay it, because it's an incredibly important component of the criminal justice system. Do you have any thoughts about this?
Well, it has to do with the statute of limitations, of course. Accusations are probably used under two situations, where an attorney such as you is very effective at reaching out to the prosecutor's office to initiate plea negotiations
Pre-indictment.
But before I even see a file.
Right.
I know you deal specifically with the screening prosecutor we've had for many years in our county, who's extraordinarily effective at reaching out, John Gingoli. He is our first or second line of review, having to do with cases, whether they're going to remain up here, get knocked down, or things like that. The accusation is extremely effective in many circumstances, because it allows you almost instantaneous entry into PTI if you're eligible. That's a mechanism for getting into PTI, as you know. As you also know, a lot of people actually who have only DP charges will ask that the prosecution nevertheless allow them to plead to an accusation of an indictable, pleading not guilty to the accusation so they can get into PTI, which is not available in DP land. That came up a few weeks ago with me personally. I'd never seen the mechanism used, but it makes sense under the circumstances that he was facing. But accusations allow you also to get what the state wants. For instance, if I want a person to receive psychiatric help, some type of medication perhaps. Suppose it's a crime that's just goofy. He's not a criminal. He does something stupid. He gets drunk. He gets high. Whatever it is, it's a rare instance. He's not the guy we're after. He's not the guy we need to protect society from.
Right.
Get him accusation, but I can tailor that accusation to virtually any type of behavior that he'll admit to. He pleads not guilty to it. He gets into PTI. Then he proves to me that he's not the idiot that the original charge made him out to be.
I've also had them come up where we decide we're going to plead him guilty to something that has nothing to do with the indictment.
Absolutely.
And look, the indictment is what it is. But if I want him to plead guilty to something that didn't go to the grand jury, it's going to have to be done by way of accusation.
Sure.
And the key that I want our young attorney viewers to understand is that this isn't optional. I mean, if you're going to be up in Superior Court and your guy's going to be pleading guilty to something, it's got to be by way of accusation unless there has been an indictment returned. Mm-hmm. That's the key. So, the bottom line on all this, do you have any advice to give to the young lawyers out there about dealing with the grand jury as a process?
Well, as a process, I think the best thing you can do is avoid it.
Well, let me put it this way. One piece of advice for young assistant prosecutors, another piece of advice for the defense bar. What do you think?
For young prosecutors, know your case, review your case, and consider negotiation before everything gets too hairy. The reason behind behind plea negotiation itself. Out beyond if we eliminate whether a case is strong or not. Okay, take that out of the equation. Everybody is trying to allocate resources responsibly. If I don't have to take this case to grand jury to prove a situation that you're already willing to admit, then I have saved that time, which I can dedicate to another more serious case, have you plead and get what I wanted out of you in the first place. Maybe it's a fine. Usually accusation cases are fines, some period of probation, whatever. And needless to say, most of them can be expunged because they're usually relatively slight. Another mechanism is if you want to avoid serious ramifications from convictions of certain types of cases. People sometimes plead guilty to accusations under Title IX for child abuse, as opposed to a sexually based child abuse, and it avoids certain ramifications.
Like going to prison.
Or Megan's Law registration, which is huge. I mean, that's spreading across like wildfire now because of the sexting cases out of those two high schools on both coasts. Megan's Law ramifications are going through the roof on that. So get in early. The earlier you get in, the more valuable anything you say to the prosecutor is. Because again, it's a matter of time. How many hours do I have to spend on a bicycle thief? I don't need to spend 10 hours